6:14 a.m., July 8th, 2026. Norfolk, Virginia. 12 federal marshals moved through the intake corridor of the Federal Correctional Institution on Brambleton Avenue, not toward the exit, toward the processing wing. The man they were looking for was already inside. He had been there for 11 days, transferred from a holding facility in Richmond after his sentencing in the Eastern District of Virginia. 44 years, federal. No parole. The judge had been clear about that. His name was Petty Officer First Class Darian Royce Franco, United States Navy. 15 years of service, a conduct record that, until 2025, showed nothing irregular. The marshals weren't there to take him out. They were there to serve him with a second indictment. The warrant had been signed by a federal magistrate 48 hours earlier. It referenced events that occurred not in 2025 or 2026, but in the spring of 2011. 15 years before anyone connected the name Darian Franco to a death at sea. Estimated investigative cost to reopen the case, over $1. $3 million in forensic reprocessing, surveillance, and federal grand jury proceedings. That figure meant nothing to the victim's family. What mattered to them was something else entirely. A woman identified in the new indictment as Jane Doe, her legal identity protected, had been missing for 15 years. Her car had been found in a parking lot at Naval Station Portsmouth on a Thursday morning in April 2011. Her keys were on the front seat. Her phone was never recovered. Neither was she. The case had been closed. The warrant had not. That distinction, one file marked inactive, one warrant that technically never expired, was what allowed what happened on July 8th, 2026 to occur at all. The 12 marshals found Franco in a processing room on the second floor. He had just been assigned a unit. He had not yet received his inmate number. The lead marshal set the documents on the table in front of him. Franco read the first page. He did not speak. The intake officer noted the time, 6:31 a.m. To understand how a federal warrant survives 15 years without being executed, you have to go back to where the file first went quiet and understand what quiet actually meant. April 14th, 2011. Portsmouth, Virginia. A call came into the Portsmouth Police Department at 7:22 a.m. A base security officer at Naval Station Portsmouth had found an unoccupied vehicle in Lot C of the contractor annex. A silver Hyundai Sonata, registered to a civilian defense contractor at a naval systems support firm operating out of a satellite office on the base. Her name was Angela Reyes. She was 23 years old. She had worked on base for 8 months, processing logistics documentation for a program that moved equipment between Norfolk and Diego Garcia. Her supervisor described her as detail-oriented and quiet. No disciplinary history. No criminal record. She had not reported for her shift that morning. She had not called in. Her phone went directly to voicemail at 7:09 a.m., 13 minutes before the car was reported. By noon, Portsmouth PD had formally requested FBI assistance. The Naval Criminal Investigative Service opened a parallel inquiry that same afternoon. The base commander ordered a sweep of all access logs going back 72 hours. What the logs showed. Angela Reyes had badged into the contractor annex at 11:47 p.m. on April 13th. She had not badged out. The after-hours entry wasn't unusual. The office she worked in had a flexible access policy for contractors processing time-sensitive logistics data. Her supervisor confirmed she had been there that evening to complete a backlog of manifest reconciliations before a morning deadline. What was unusual? A second badge record, 4 minutes later, showed a Navy enlisted service member entering the same annex building. His access wasn't anomalous. His duties gave him standard overnight access to multiple base facilities. But the overlap was narrow. 2 people. The same building. A 4-minute gap. That service member's name was Darian Franco. He was 24 years old at the time, 3 years in the Navy. A clean service record with no prior disciplinary actions. Investigators brought him in within 48 hours. He was cooperative. He said he had gone to retrieve a toolkit he had left in a mechanical storage room on the first floor. He said he had not seen Angela Reyes. He said he had been inside for approximately 8 minutes and then returned to his barracks. He provided the name of a fellow service member, Petty Officer Third Class Kyle Denard, who could confirm he had returned to the barracks before midnight. Denard confirmed it. The polygraph examination administered to Franco 10 days later showed no deception on the primary questions related to Reyes' disappearance. The 2011 investigative file was eventually downgraded from active to pending, and then in February 2012 closed for lack of investigative leads. Angela Reyes was listed as a missing person with the National Crime Information Centre. Her case was assigned to a cold case unit at the Portsmouth field office. No additional significant evidence emerged. The file sat, what nobody outside the Bureau knew in 2012, and what would not surface for another 14 years, was that one piece of physical evidence had not been fully processed. The forensic team working Reyes' vehicle in April 2011 had collected a partial palm print from the driver's side exterior door panel, not the handle. The panel itself, low, near the bottom of the door. The placement suggested contact during a push or a lean, not a normal entry. The print was partial, approximately 62% of a full palm print. In 2011, the FBI's integrated automated fingerprint identification system had limited capability for partial palm print comparison. The print was entered into the system. No match was returned. The evidence was catalogued, sealed, and placed into cold storage at the FBI's Norfolk Evidence Facility on Granby Street. It stayed there for 14 years. What changed everything had nothing to do with the Reyes case. Not directly. Not at first. What changed everything started in October 2025 inside a federal courtroom in Norfolk. Darian Franco, by then a petty officer first class with 15 years of service, was on trial in the Eastern District of Virginia on charges of aggravated assault resulting in death. The victim was a fellow Navy sailor, Seaman Marcus Elliott Webb, who had died in May 2025 following an altercation aboard a berthed vessel at Naval Station Norfolk. Franco had been the last person to see Webb alive. Forensic evidence placed him at the scene. A witness statement from a third sailor described an argument the night before Webb's death. The trial lasted 4 weeks. The jury deliberated for 11 hours. On November 19, 2025, Darian Franco was found guilty on all counts. Sentencing was scheduled for July 2026. The case made regional news. Some national pickup. A Navy service member convicted in the death of a fellow sailor. It ran for a few days, then nothing. Inside the FBI's Norfolk resident agency, the conviction generated something different. A cold case analyst named Supervisory Special Agent Patricia Gould had been with the Bureau for 22 years. She worked out of a second-floor office that looked out onto a parking structure. Her caseload consisted entirely of inactive federal files from the Eastern District, going back to 2004. She had not worked the Reyes disappearance in 2011. She had inherited the file in 2019 when the analyst who held it retired. When Franco's conviction appeared on the internal case notification system, a routine cross-reference function that flags active convictions against names appearing in dormant files, Gould's system flagged the match within 48 hours of the November verdict. She pulled the Reyes file that evening. She read it in 2 sittings. I spent time going through the sequence of events in that file, and one detail kept coming back. Not the palm print, not the badge logs, the polygraph. The examiner's report ran 12 pages. Buried in the footnotes was a caveat that rarely appears in standard polygraph documentation. The subject had exhibited what the report called atypical baseline suppression on 2 control questions. Not the crime-specific questions. The controls. The examiner had flagged it, noted it as inconclusive, and moved on. In 2011, with no physical match and a corroborated alibi, there was nowhere for that flag to go. Gould noticed it 14 years later. She formally requested permission to reopen the Reyes file as an active cold case inquiry on December 3, 2025. The request was approved by the special agent in charge of the Norfolk field office on December 9th. The first call Gould made the following morning was to the FBI's laboratory division in Quantico. She wanted to know whether the 2011 palm print could be rerun against updated biometric databases. The answer came back within 6 hours. The next generation identification system had been expanded significantly since 2011. Palm print matching capability had improved substantially, particularly for partial prints in the 60 to 70% range. More importantly, Darian Franco's biometric file had been updated 3 times since 2011. Once during a routine security clearance renewal in 2015, once after a base access upgrade in 2018, and once during the pre-trial processing for his 2025 assault case. The 2025 biometric submission was the most complete record on file. Quantico requested the original evidence seal number. Gould pulled it from the file. 47 minutes later, she confirmed that the 2011 palm print evidence was still in cold storage at the Granby Street facility, intact, chain of custody unbroken. Authorization to retrieve and reprocess was granted on December 11, 2025. The evidence was transported to Quantico under Federal Evidence Protocol on December 15th. Here's what most people don't understand about cold case forensics. The evidence doesn't change. The technology does. A partial palm print that returned no match in 2011 is the same physical artifact in 2025. What's different is the resolution of the system comparing it. The question was whether 14 years of database expansion and algorithmic refinement would be enough to close a 62% print. It was. The Quantico palmprint examiner submitted her findings to the Norfolk Field Office on December 29, 2025. The 2011 partial palmprint from the exterior door panel of Angela Reyes' vehicle matched, at a confidence level of 94.3%, the palmprint on file for Darian Royce Franco. The match point count exceeded the Bureau's minimum threshold by a significant margin. The examiner's report noted that the specific pattern of the lower hypothenar region, a distinctive loop configuration near the heel of the palm, was present in both the 2011 partial and Franco's 2025 submission. This was not a borderline finding. The examiner characterized it as definitive. Gould read the report twice. Then she called the SAC. The reinvestigation moved to the next phase. The palmprint established presence. Contact with Reyes' vehicle at some point. It did not by itself establish when that contact occurred or what it meant. Franco's defense would argue the print could have been placed at any time through incidental contact on base. The 2011 polygraph finding remained ambiguous. The alibi from Denard remained on record. Gould needed the alibi. Kyle Denard. She pulled his file on January 4, 2026. Denard had left the Navy in 2014. He had worked a series of private sector jobs in the Hampton Roads area through 2018. In March 2019, he had been indicted in the Western District of Kentucky on federal wire fraud charges related to an investment scheme that had defrauded 17 individuals of a combined $3 million. He had been convicted in November 2019 and sentenced to 8 years at the Federal Correctional Institution in Ashland, Kentucky. He was still there. Projected release, 2027. Gould coordinated with the FBI's Louisville Field Division to arrange a formal interview at FCI Ashland. The interview was scheduled for February 12, 2026. 2 agents made the drive from Louisville to Ashland that morning. They met with Denard in a conference room reserved for legal and federal visits. The session was recorded. Denard had not been contacted by anyone from the FBI about the Reyes case since 2011. He had not been told in advance what the interview would cover. He was advised of his rights. He was told the interview was voluntary. He agreed to proceed. The agents placed a photograph of Angela Reyes on the table. Denard looked at it for approximately 15 seconds. Then he said, "I knew you'd come eventually." What followed was a 3-hour recorded statement. Put yourself in the position of those 2 agents for a moment, sitting across from a man who had held a false alibi for 15 years, watching him choose to give it up. They had prepared for resistance, for deflection, for an attorney request. What they got instead was someone who had carried something for a decade and a half and had, by his own account, decided he was tired. Denard's statement, reduced to its core, was this. On the night of April 13, 2011, he had not seen Darian Franco return to the barracks before midnight. He had not seen Franco that evening at all. When investigators had approached him in April 2011, Franco had contacted him in advance. That contact had not been a request. Denard characterized it as a statement of what Denard was going to say when investigators came to him. He described Franco as explicit, as saying that if Denard did not confirm the barracks alibi, Denard's younger brother, then 17, and living in a group home in Richmond, would be in a position to have problems. Denard had no reason to believe this was an empty statement. He had known Franco for 2 years. He knew Franco had connections outside the base. He gave the alibi. He had never recanted. Until February 12, 2026. What's most striking about this case isn't the forensic match. It's that a coerced alibi held for 15 years without anyone pressing it harder. One conversation. One threat. One statement from a scared petty officer 3rd class. And a case goes cold for a decade and a half. The agent secured Denard's signed statement and returned to Louisville. Gould received the transcript on February 14th. She had, at that point, 2 evidentiary pillars, a forensic match placing Franco at Reyes' vehicle, and a recanted alibi with a documented coercion claim. She also had the 2011 polygraph anomaly in the record, which now read differently in context. The obstacle was significant. Neither piece of evidence independently resolved the central question. Angela Reyes was still missing. Her body had never been found. Without a body, a forensic match to a vehicle exterior and a recanted alibi were serious, but not individually sufficient to support an indictment for a capital-level offense. Gould escalated to the cold case unit at FBI headquarters in Washington. They assigned a senior attorney from the criminal division to review the evidentiary package. The review took 3 weeks. The determination, delivered on March 7, 2026, was measured. The evidence package was sufficient to support grand jury proceedings on charges including conspiracy to obstruct justice, for the coerced alibi, and potentially for offences related to Reyes' disappearance, depending on what the grand jury process surfaced. The case was formally reopened as an active criminal investigation on March 9, 2026. Here's a take that may generate some pushback. What allowed this case to go cold in 2011 was not a technology failure. It was a documentation failure. The polygraph anomaly was in the file. The badge log overlap was in the file. The evidence seal had been maintained in cold storage without interruption. Everything that eventually broke this case open was sitting there in 2012. What was missing was a mechanism to force someone to look at it again before a second victim died. The Bureau has improved its cold case review protocol significantly since then, but the question of why that review didn't happen until a second conviction forced the flag is worth sitting with. The grand jury in the Eastern District of Virginia convened on March 24, 2026. Federal prosecutors presented the forensic match findings, Denard's recanted statement, the 2011 badge logs, and supplementary evidence gathered during the reopened investigation. The supplementary evidence included 2 additional items developed since January 2026. First, a review of Franco's financial records from April 2011 showed a cash withdrawal of $400 from an ATM on base at 11:32 p.m. on April 13th, 15 minutes before Angela Reyes badged into the contractor annex. The withdrawal was not inherently significant. Its timing was. Second, investigators had located a civilian maintenance worker who had been on base in the early hours of April 14th, 2011. He had not been interviewed in the original investigation. His name had not appeared in the initial witness canvass because he had accessed the base through a contractor gate on the opposite side of the installation, and his records had not been cross-referenced. In January 2026, investigators reviewing all base access logs from that night found his entry. He was interviewed in February 2026. He described seeing a male service member in uniform near the contractor parking lot at approximately 1:15 a.m. on April 14th, roughly 90 minutes after Reyes's last confirmed badge entry. He had not thought anything of it at the time. He had not reported it. He described the service member as tall, mid-20s, moving quickly toward the vehicle lot perimeter. He could not make a positive identification. But his statement placed a service member at the lot at 1:15 a.m. It was corroborating context, not a direct identification. The grand jury deliberated. On May 6, 2026, the grand jury returned a true bill, a formal indictment. Darian Royce Franco was indicted on 3 counts: obstruction of justice for the 2011 coerced alibi, unlawful restraint, and first-degree federal murder. The latter charge based on what prosecutors characterized as evidence sufficient to proceed, with the understanding that the case would be substantially built around forensic and circumstantial evidence given the absence of remains. This is not common. Federal murder indictments without recovered remains are pursued in a relatively small number of cases. They require an evidentiary threshold that prosecutors and the court assess as adequate to proceed. In this case, the combination of forensic placement, coerced alibi, witness positioning, and the convicted sailor's existing record of lethal violence toward a fellow service member was deemed to meet that threshold. What do you think? Did the system fail Angela Reyes in 2011? Or was this the outcome of a system working within its actual limits? The comment section on this one has been running for 2 weeks since the story broke, and the divide is sharper than you'd expect. There's a line in the indictment that reads almost like fiction. The defendant, having previously caused the death of the victim and coerced material witness testimony to conceal his actions, continued to serve in an official capacity within the United States Armed Forces for a period of 15 years, during which time he committed additional acts of violence culminating in the death of a second victim. 26 words to describe 15 years of a missing woman's family not knowing. 3 days before the indictment became public, an attorney retained by Angela Reyes' family received a sealed notification from the U.S. Attorney's Office for the Eastern District of Virginia. Her parents had been notified that a development in their daughter's case had occurred. They were not given specific details at that stage, only that a formal legal proceeding had been initiated and that they would be contacted again before any public announcement. Her father, who had relocated from Portsmouth to Raleigh, North Carolina after 2011, received the call on May 3, 2026. He asked the attorney one question. The attorney told him what the indictment said. He did not speak for approximately 40 seconds. Then he said he needed to call his wife. The FBI's Victim Services Coordinator made contact with the family on May 4th. The family was not available to comment publicly before the indictment was announced. They issued a brief statement through their attorney on May 8th, 2 days after the public announcement. "We have waited 15 years for this. We ask for privacy as we process this development. We trust in the legal process." The family did not mention Angela Reyes' name in the public statement. That was deliberate. Her name had been protected in the indictment. The family maintained that protection. The warrant was served inside the Federal Correctional Institution Processing Wing on July 8, 2026, 11 days after Franco had arrived to begin serving his 44-year sentence. The 12 federal marshals who carried out the service were not executing an arrest. Franco was already in custody. The service was procedural, a formal notification of additional federal charges. But procedurally, it required physical delivery, a face-to-face reading of charges, and documented receipt. The lead marshal read the indictment charges aloud in the processing room. The intake officer and a facility compliance officer were present. Franco's bureau-assigned attorney, his current representation from the assault case, was notified simultaneously by phone. Franco did not respond to any of the charges being read. He was escorted back to his assigned unit. His attorney filed a motion for continuance on May 14th, prior to the July warrant service, requesting additional time to review the new indictment and the underlying evidence package. The motion was granted. Pre-trial hearings in the new case were scheduled to begin in September 2026. The coercion charge against Kyle Denard, for his original false alibi statement, was reviewed by the Department of Justice. Given Denard's cooperation, his recantation, and the fact that he had provided his corrected statement without a plea agreement or immunity deal, prosecutors recommended against additional charges. The formal declination was issued on April 2nd, 2026. Denard was not released. He returned to serving his wire fraud sentence at FCI Ashland. As of July 8th, 2026, several elements remained unresolved and would carry forward into the new legal proceedings. Angela Reyes' remains had not been found. The indictment proceeded without them. The question of where she had been taken and what had happened in the hours after 1:15 a.m. on April 14th, 2011, remained open. Investigators working the cold case since March 2026 had conducted a secondary review of property records and facility access logs for locations in the Portsmouth and Norfolk area that Franco had access to in 2011. That review was ongoing as of the indictment date. No announcement of any discovery had been made. Franco's 15-year service record was under separate review by the Department of the Navy's Judge Advocate General Corps. 3 incidents during his service, 2 administrative flags and 1 informal complaint from a junior sailor in 2019, had been re-examined following his 2025 assault conviction. The results of that review were not public. The maintenance worker whose statement placed a uniformed service member near the parking lot at 1:15 a.m. was listed as a potential witness in the new case. He had been cooperative throughout the investigation. His identification remained non-specific. He could describe what he saw, not confirm who. FBI cold case analyst Supervisory Special Agent Patricia Gould was not named in any public announcement. Bureau policy does not identify cold case analysts in press releases related to active proceedings. One detail stuck with me in reviewing this case. The 2011 palmprint examiner's original report noted the partial print's location on the door panel and described it as suggesting contact during a push or a lean. That observation, recorded in 2011, catalogued, sealed, sat in that evidence file for 14 years. The technology to match it arrived later. The observation was always there. One more thing about how this case reached July 2026. The cross-reference system that flagged Franco's name when his assault conviction was entered. The function that put the Reyes file on Patricia Gould's desk within 48 hours of the November 2025 verdict had been implemented bureau-wide in 2021. Before 2021, that kind of name match between a new conviction and a dormant cold case file required a manual review request. Before 2021, the Reyes file stays closed. The assault conviction still happens. Webb still dies. Franco still serves 44 years, and Angela Reyes' family never gets the call. Will cases like this, where a second crime finally unlocks a cold case, become a model for proactive cold case review, or will it take another tragedy each time? Comment yes or no on whether you think the Bureau's current protocols are enough. The new indictment did not affect Franco's existing 44-year sentence. It ran concurrent to pending pre-trial proceedings. Depending on the outcome of trial, additional consecutive sentences were possible. His attorney's public statement on May 8, 2026, said only that Franco maintained his innocence with respect to the new charges and that the defense looked forward to presenting its case in court. The Reyes family's attorney issued one additional comment on July 9, 2026, the day after the warrant was served inside the facility. She said, "The warrant is served. The file is open." 15 years is a long time. The family hopes the process now moves forward. The case is active. Pre-trial hearings in the Eastern District of Virginia are scheduled for September 2026. The forensic evidence is catalogued. The grand jury record is sealed. Denard's statement is on file. Angela Reyes is still listed as missing with NCIC. Her status will not change until the court process concludes. The network of facts around this case, the badge logs, the palmprint, the coerced alibi, the maintenance worker's sighting, the financial withdrawal, forms an evidentiary ring that prosecutors have characterized as sufficient. Whether it is sufficient to sustain a conviction without recovered remains will be determined by a jury in a federal courtroom sometime in 2027. The cold case file on Angela Reyes is no longer cold. The question of where she is has not been answered. Those two facts, one a legal development, one a human reality, are not the same thing. They will not be resolved at the same time. And for the Reyes family, sitting in Raleigh, North Carolina on the morning of July 9th, 2026, the distinction between the two is the difference between a legal proceeding and a life. The warrant was served. The case is not closed. If you want to follow the pre-trial hearings as they develop in September, and this case has several evidentiary questions that will be argued before any jury sees them, subscribe so we have the full next file ready when the proceedings begin. The system flagged a name in November 2025. A cold case analyst pulled a file. A forensic lab reran a 14-year-old palm print. A man in a Kentucky federal facility decided he had held a false alibi long enough. None of that brings Angela Reyes back. The file that was closed in February 2012 is open again. That is what it is. Nothing more. The indictment is on record. The trial date is pending. The location of Angela Reyes remains unknown. Somewhere in the Portsmouth and Norfolk area. In a building, on a property, in a location that investigators are still reviewing. There may be an answer to the one question that 15 years and a federal indictment have not yet resolved. That answer, if it exists, has been waiting as long as the warrant.